you flowers. I can buy myself flowers.
Miley Cyrus is asking the court to dismiss the copyright lawsuit, arguing the case has a fatal flaw. Sometimes lawyers take the approach of the kitchen sink, but it can backfire. The Miley Cyrus lawsuit was an interesting one. We looked at the complaint in its entirety. I'm a real lawyer. I run an actual law firm, and I've done this for over 10 years. And, as an actual litigating attorney, I can just kind of give you some of my perspective here because we have an answer, all right? And it's not an answer. It's a motion to dismiss. So what I want to do is just kind of, let me share my screen. All right, so Miley Cyrus gets sued. And now Miley Cyrus is asking the court to dismiss the copyright lawsuit against her over her song Flowers, and she's arguing that the case has a fatal flaw. So, copyright infringement lawsuit against Miley for Flowers is remarkable for the large number of people and businesses it is suing, from Miley Cyrus herself to the songwriters for the song, the publishers, to even streaming services that offer the song, to retailers that sell it. And so, just for context, let me show you. Right, so it's always helpful to actually look at what the pleading paper looks like. So let me show you. So this is the actual motion to dismiss that we're going to be looking at. But just for context, we go, okay, so this is in the California District Court, and these are the parties. So it goes, the plaintiff is this Tempo Music Investment. So we've talked about this so much. I do this as well. We literally just closed almost $10 million on a music catalog sale, like a week or two ago at this point. And, it's very common that investment groups, equity funds, these companies are just coming in and they go, legacy music or music that's really popular is more valuable than gold and oil. And so these people who are coming in who have no idea about music, and they're not music people whatsoever, they're just people with deep pockets. So Tempo Music Investments is not someone who's like, oh, you violated the copyright to my song because I'm a songwriter or something like that, right? This is an investment company. That's really important. So suing Miley, and then it's a very long list, okay? And even the attorneys at the top, they're like, hey, these are the attorneys that are coming in on behalf of Miley Cyrus. And then you just you see a publishing company, you see the other songwriters, the publishers. I mean, it's just a laundry list. And they're even including, there's Amazon, right? Apple Music, Pandora, Disney's getting looped in, Target, Barnes and Noble. For me, I can just say that sometimes lawyers take the approach of the kitchen sink and they go, we don't know who's going to fold. We don't know who's going to come in and maybe settle. And so we're going to name everyone we can possibly think of, okay? But it can backfire because sometimes those people who were maybe improperly named, and they're like, I'm Amazon, I have safe harbor under the Copyright Act, you shouldn't have named me. And so you come back and you're like, I'm going to file a motion to dismiss, I want my attorney's fees, and I want the judge to spank you. So in any case, lots of people were named here, but lawyers for Miley Cyrus say it's remarkable for the reverse reason: the small number of plaintiffs who allege Flowers ripped off Bruno Mars's song When I Was Your Man. So basically they go, well, you have this investment company that came in, and this investment company owns a teeny tiny bit of the song, not the whole song. It's very common that artists and publishers and record labels, they will only own a certain portion of a song and they share it, right? There's lots of owners. And so this investment company owns a portion of it. And they go, well, that's interesting. So what we do know is that investment company sues a whole lot of people and publishers and companies and all this. But conversely, they're like, it's weird because no one else is suing Miley Cyrus. That's interesting. All right, so that's essentially what they're saying here. Miley's lawyers have filed a motion to dismiss, arguing that the case has a fatal flaw. Only Tempo Music, the music rights investor that owns a part of the rights to Flowers, has filed the lawsuit. And the other owners of the composition, including Bruno Mars, has not joined the case. Okay, so Tempo Music, quote, brings this copyright infringement action all by itself without any of that musical composition's co-authors or other owners. Cyrus's lawyers wrote a memorandum arguing for the dismissal, which we will read here in a sec. So, in fact, why don't we just go to that? Because here's the thing. A motion to dismiss is something that is filed when you can ask the court to make a decision right away. You go, court, I understand all we have right now is a complaint. But looking at just the complaint and the four corners, they fail. As a matter of law, and here's why. And there's a list of reasons, right? There might be an issue with the jurisdiction, right? So someone might say, Your Honor, you're not allowed to even hear this case because maybe in a contract it said that we would deal with this in Arizona. Well, you're not Arizona, you're Florida. You see what I'm saying? So there can be reasons that the court is empowered to just get rid of cases. They're like, I'm not going to hear it. I'm never going to like see if there was actually copyright infringement. So that's what's happened now. There isn't an answer. There isn't a countersuit. This is a motion to dismiss. So let's go through kind of the formalities. There's a table of contents of all the good stuff that's in this motion to dismiss, the table of authorities. These are all the cases that are referenced in alphabetical order. Okay. Here are the statutes. Alrighty. So here is what Miley Cyrus's lawyers have to say. Defendants Miley Cyrus also sued as the publishing company MCEO Publishing. Gregory Hine also sued as songs by Gregory Hine. So they go through and they go, this is basically, these are the songwriter defendants respectfully submit their position. So the plaintiff investor or investment company is not an author or apparently even a music publisher. Instead, it is an investment company that acquires songs and it alleges that it purchased one co-author's portion of the copyright in a musical composition titled When I Was Your Man. Plaintiff brings this copyright infringement action alone without any of the musical composition's co-authors or other owners, alleging that the musical composition titled Flowers infringes the copyright in When I Was Your Man. Now here's the thing. After I covered the original complaints, we made some clips for, Top Music Attorney on social media. And, I gotta tell ya, I can buy myself flowers, right?
I should have bought you flowers. I can buy myself flowers.
In any case, just kind of comparing it, right? So the words, the phrasing, the flow of it, okay, if we are going to have this presented in front of a jury and we play Mileys and we play Bruno's back to back, it's tricky. They're very, 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 very similar. And that's important. But at this point, remember what we said. We go, well, the court's not going to look at this and go to the merits of the case. The court's not going to listen to the songs back to back. This is not what we're talking about right now. But they do discuss that briefly. All right, so the songwriter defendant, so Miley, categorically denies copying and allegedly elements. They're just elements. They're scattered. They're unprotected ideas. They're just basic building blocks, right? So AKA, they're just like the same chords. It's no big deal. However, plaintiff's claim suffers another fatal flaw that mandates dismissal at the pleading stage. The Copyright Act expressly prohibits that only a legal or beneficial owner of an exclusive copyright may sue for infringement. Let's take a quick beat on that. What they're claiming is that they say, pursuant to 17 USC 501, Section B, the Copyright Act says, look, if you are a co-author in a song, which is what we have here, you as a co-author, you still have all the great rights that come with copyright protection. So there's the right of reproduction, of distribution, right? You can adapt, you can make derivative works of your songs. These are like exclusive rights. You can publicly perform your song. You can display, if you've made like a picture or a creative work of some kind, right? Where there's a visual element. So this is the good stuff that the Copyright Act gives to us as creators. And if you are a joint author, so there's more than one of you, each one of you have those separate rights individually. It's not like shared, there's no percentages. So this is the good news. But under 501B, right, what they're arguing is that they go, well, if you license it to someone, if you sell it to someone, all those exclusive rights don't necessarily carry. And so they go, basically, what we're saying is that an investment company came in and they're like, hey, we're going to make some money with a portion of the song that we're buying. But for them to now be like, hey, you violated our copyright. We want statutory damages. The answer is, well, pursuant to this motion to dismiss, Your Honor, you should kick it out. They don't have standing. So that goes back to like, if you can't be here in this court making these claims, it doesn't matter what you're saying, it gets kicked out. So that's what the argument is. If you are someone that is needing help in the music business, at the end of this video, you can check out topmusicattorney.com. I have courses, I have free stuff just to kind of get you started. If you do want to deep dive, if you do want to train with me, I always say go through my music business program, which is how to think like a record label, become a record label. And then if you do want to get into touch with me or one of my lawyers, we got you covered. It is well established in this circuit, right? So this jurisdiction, that an assignee or licensee of a single co-author's copyright interest lacks standing because the assignee or licensee does not have exclusive rights pursuant to Section 501B, and it's required to confer standing. Rather, the rights are shared non-exclusively with co-authors. Okay, so that is true even where the assignment purports to grant exclusive rights because one co-owner only has non-exclusive rights. So let me tell you what my practical experience with this has been. In order for a sub-licensee, so meaning investment company. Let's pretend I'm representing the investment company. I go, well, before we file the lawsuit, if you don't have the right to represent all of the owners, if you don't have all of the rights, you don't get to seek the protection of the Copyright Act. And so what they're saying is they're like, well, this is like this one little lone ship over here of this investment company going out being like, we want statutory damages, give us the millions of the dollars, which we have seen. And I've been extremely critical recently of especially major record labels that are weaponizing the Copyright Act. And they go, well, there's statutory damages because you allegedly did the copyright infringement thing, or you actually did, right? And it was a mistake, it was an accident, it was whatever. And so then they're weaponizing it to go after other businesses. And so then this is like a business model. So you have these companies who come in and they buy the rights from Justin Bieber and they go, well, now we represent your catalog. And so now we're not only going to exploit it, we're not only going to collect all the royalties forever and ever on your popular songs, but we're going to hire companies who can go and get you, sync licensing. We want to get it put into commercials and TV and film and all that. It's fine. It's an asset. So they're doing what they can to exploit it. And then at some point, labels, these investment companies, they go, well, our assets are really valuable. And the Copyright Act allows us to sue if there's been an allegation of copyright infringement, right? And we hold the copyright certificate. And, as we've discussed on this channel many, many times, you can sue for statutory damages up to $150,000 if it's willful. So, AKA, that means $150,000 times a couple of infringements. We get into the millions of dollars. And so that's why I say I'm just noticing that as part of the new business model for owners of copyrights, it's to really weaponize the Copyright Act. And, I go back to this is amazing otherwise. This is a great protection for you creators out there. And I go, you're doing yourself a massive disservice by not getting your copyright registrations because you actually do need the piece of paper before you can sue, right? In order to get your statutory damages, in order to get your attorney's fees. And so if you don't take that step, bad things happen when it comes time to call me and you're like, Krystle, help. So let's work together on this. But in any case, they go, all right, so, with the allegations, plaintiff acquired the copyright interest, and it was only on behalf of one of the authors. So they go, When I Was Your Man was co-written by Bruno Mars, Philip Lawrence, Ari Levine, and Andrew Wyatt. And recordings of that musical composition were released to the public in January of 2013. Then, investment company comes along and purchases the rights on behalf of only Mr. Lawrence. So that's where we go back to, well, the fatal flaw, as Miley's attorneys would put it. The fatal flaw that they're pointing to is they go, well, investment company, you messed up. Because, yeah, you bought these interests, but pursuant to the Copyright Act, you were supposed to get the right to sue to enforce those rights from everyone because you're not one of the original authors. So I don't know. It's kind of like this snooty, we get to, I don't know, unless you're one of the originals, you lose rights. It's not a bad argument. And so they're saying again, court, kick it out. Don't even hear it. Don't even consider it. And the reason why, with the comparison of the songs is just because the songs do sound so much alike and they are so very similar. It's odd. And then, we've just discussed about the significance of the song to Miley and how there are some connections that kind of make this not so great. We hope that Miley is successful at this stage because otherwise she really does have to fight this on the merits of the actual lawsuit. All right, so let's go to just that piece I was mentioning. So they go, hey, 12b6 motion, they state the law, right? And then they get into the 501b analysis. They go, so for standing, in order for the investment company to bring this lawsuit, there has to be a legal or beneficial owner of an exclusive right under the Copyright Act that's entitled, right, to this kind of relief and this kind of protection. I mean, so it's what I'm saying. They're just like, sorry, no can do. So they go, plaintiff's not a legal owner, right? So not one of the original authors, not entitled to these exclusive rights of distribution, adaptation, performance, all this stuff, and really the right to sue. Because what they're saying is they go, well, you essentially made a derivative work, right? So you guys know we talk on this channel about interpolation, and interpolation being, it's not sampling, right? We're not saying we went and actually took Bruno Mars's song and put it into our new Miley Cyrus song, right? We're saying we took potentially, that there were elements taken from it, similar wording, similar melodies, similar chord progressions. And it really was the inspiration for a new song that was essentially based on the other one. So it's a derivative work, which is something that is protected under the Copyright Act. So they're saying it's one of the protections that you actually don't have, Mr. Investment Company. So that's the argument. No interest. Okay, so there's also if you are a songwriter, so I write music, I collaborate with people, all kinds of good stuff. And something that is common is that some people will assign the rights of royalties. There's a company called Sound Royalties, for example, and you can take out a loan from Sound Royalties, right? If they'll take you and you can say, okay, I want to take out $1 million and I'm going to use that $1 million to fund whatever my independent record label or my career or whatever. And then there's, essentially a security interest put on your music because hopefully your music is making money on Spotify and all the good stuff. And so you're able to kind of do these deals and assign the rights to your royalties to someone else. So again, they're going back through, they're like, there's all kinds of ways that you can seek protection under the Copyright Act. But again, if you are an assignee and you don't have all the okays from all the different authors, which you don't, then you're kind of out of luck. All right, so Tempo brought the lawsuit. This was in September, right? So saying, there had been a violation of copyright. They had purchased Philip Lawrence's share, including his share as a co-author of the hit song When I Was Your Man. There were other authors. We talked about that. And of course, the original lawsuit alleges that Miley Cyrus's Flower song duplicates numerous melodic, harmonic, and lyrical elements of When I Was Your Man. Okay. When Flowers came out in early 2023, many listeners noted the similarities between the lyrics of When I Was Your Man and Flowers. For instance, When I Was Your Man features the line, I should have bought you flowers and held your hand, while Miley Cyrus's song contains the line, I can buy myself flowers and I can hold my own hand. Many interpret this as an intentional echo of the Bruno Mars's lyrics, a kiss off to Cyrus's ex, Liam Hemsworth, who is said to be a fan of Bruno Mars and When I Was Your Man. All right, so Orko, why don't you just pop in real quick? When we were covering the complaint originally, you had a little more context on this. So what was the deal, right? Wasn't it, wasn't that like their wedding song or something?
I'm trying to remember. I think it was like something like he was like dedicated it to her in some fashion, and like that was like his song to her or whatever, something like that.
Well, what do you
So
think?
if Bruno Mars was attached to this and he was, trying to throw a fit about it, I could see it being more of whatever. It's just so sleazy. But I get it. But I get it. You buy the rights to songs and you buy these things so you can exploit them in different ways. It's just crazy how like seedy it is. And then the fact that this investment firm they don't even own everything all outright, yet they're trying to claim everybody else's money. And then what are they going to do? Divvy it up? I didn't ask for you to step in, my guy. Like, what's the count? You know what I mean?
What they're doing at this point is that Miley and her team, they're trying to get this thrown out real quick with a motion to dismiss. There will be a response, and I'm going to make sure to cover it. So don't forget to subscribe. So we'll see you on the next one. I'm Top Music Attorney.